Good afternoon. Thanks to everyone here for being here. I'm Jay Griffin, Chair of the Hawaii Public Utilities Commission. I'm joined today with Commissioner Jennifer Potter and Commissioner Leo Asuncion. We also have our Commission Counsel, Chief Counsel Caroline Ishida, and Staff Attorney Mark Kayatsu. We also have Elsie Terada as our court reporter today. Just a few housekeeping matters before we get started. Bathrooms are located in the basement below. The bathroom codes are on the door, I believe at the desk where you checked in. Please silence and turn off all cell phones and mobile devices for the duration of the hearing. It is very important that at all times that the Commission and our court reporter are able to hear the arguments from the parties before us today. And if you must take a call, please leave the room as a courtesy to the others here. From time to time, I may call brief recesses, and if recesses are called, please continue to observe quiet here. This is a hearing to receive oral arguments on Life of the Land's motion for relief from order number 32600. Life of the Land filed its motion on September 11th, 2019. And responses by Hawaiian Electric and the Consumer Advocate were filed on October 15th, 2019. On November 14th, 2019, Life of the Land filed a reply brief. And on November 18th, 2019, Hawaiian Electric and the Consumer Advocate filed their own respective briefs. Copies of these briefs, as well as the other documents filed in this docket, are available online through the Commission's document management system. You can find that by going online to our website and accessing it through docket number 2013-0423. I believe we had pamphlets available as you walked in on information on how to access some of this information. This is not a public hearing. The Commission is here to allow the parties and Life of the Land to present oral arguments on Life of the Land's written motion for relief. The Commission will then take this matter under advisement, and after considering the oral arguments today in the parties' briefing, will issue a written order at a later date. You can subscribe to this docket on our website, and again, information on how to do that is available through the pamphlet that we provided. Public comments can also be submitted to this docket through the Commission's document management system, as well as through regular mail. We have flyers that were available. You can find out how to do that on our homepage. Ms. Tirado will be transcribing today's hearing. It's critical that she's able to hear clearly what each party is saying to ensure that this hearing is transcribed accurately. Disruptions which interfere with the parties or Life of the Land's ability to conduct their oral arguments or interfere with the court reporter's ability to transcribe may result in suspension of the hearing. The Commission will use the transcript as part of its deliberations. It will make the transcript available online after the Commission issues its order on the motion. Transcripts may also be ordered from the court reporter separately. In addition to all of you present here today, we are streaming the hearing live through our website, and the Commission will post a recording of the hearing on the website. Again, it's important to ensure that those who are viewing remotely may be able to watch the recording later, have an unimpeded view. Looks like we have nothing blocking the camera, so we're good. So to begin, can we first have the appearance of the representatives of the parties and their participant here from your attorneys, starting with Life of the Land.
Aloha and good afternoon, Commissioners. Lance Collins, attorney for participant Life of the Land, and with me is Henry Curtis, Kat Brady, and Bianca Isaki.
Good afternoon, Chair Griffin, Commissioner Potter, Commissioner Asuncion, members of the Commission staff. Lane Tsuchiyama, appearing on behalf of the Division of Consumer Advocacy. Along with me to my right is Edward Knox, attorney for Division of Consumer Advocacy, and to my immediate rear is Dean Nishina, who is the Executive Director of the Division of Consumer Advocacy.
Good afternoon, Commissioners. Randy Wada for Hawaiian Electric Company. I'm here today with Rebecca Matsushima, the Director of Renewables.
Thank you, and with that, we will proceed with the arguments. First, as the movement, Life of the Land will go first, and have up to 10 minutes to present their arguments, followed by questions from the Commission staff. They will then be followed by Hawaiian Electric, then the Consumer Advocate, and as rebuttal, Life of the Land will go at the end. With that, please begin.
Thank you. We would like to thank the Commission for the opportunity for a hearing. We'd also like to thank the Commission for allowing us to file replies and would like to apologize for their brevity as well as any errors they contained. in light of the fact that we only had less than 48 hours to draft and file them. Life of the Land has moved this commission for relief from order number 32600. In summary, this commission has authority to grant the relief requested. A Rule 60 type motion differs from a Rule 59 type motion for rehearing or reconsideration as contemplated by HAR 16-601-137, in that the change in circumstances had not occurred at the time of the rendition of the order or 10 days thereafter. As to the merits of the motion, Life of the Land presents three separate matters of concern that warrant relief from the order. First, NPM did not obtain site control within 120 days after the execution of the purchase power agreement. Second, the Commission did not conduct the statutorily required greenhouse gas emissions analysis, and the obligation of the Commission to do so was not clearly delineated by the decisions of the Supreme Court until May of this year. Third, the pricing of the electricity from this project is not reasonable, prudent, or in the public interest, and the long delay in moving this project forward warrants, in the minimum, vacating of the order and reopening the docket. The Commission has expressed in broad statutory authority to grant all or a portion of the relief requested in this motion. Please see HRS 2696, 2697, 26916.22, as well as 26915. This view has been confirmed in Pacific LightNet versus Time Warner Telecom, 131 Hawaii. Administrative agencies generally have the inherent power to reopen or to modify and rehear prior decisions. That's in Re Trentino 446A2. An administrative agency has the inherent authority or power to reconsider or to reopen a prior decision. Mushler versus New Jersey Department of Environmental Protection, 766A2. It has also been held that the power to reappraise and modify a prior determination may be invoked to protect the public interest. Trap Rock Industries versus Sagner 335A2. This commission has broad authority to grant relief from the order. And we cite In Re application Kauai Electric Division, 60 Hawaii. Said another way, elsewhere, no statutory provision prohibits reconsideration, reopening, or granting relief from an order. It is allowed. Quote, it is generally accepted that in the absence of a specific statutory limitation, an administrative agency has the inherent authority to reconsider its decisions, end quote. That's Mactal versus Chow, 286F3rd. Mactal noted two opposing interests in such proceedings. One is for finality of decision, while the other is to ensure that the public agency makes the right decision. The reasonableness of the kind of relief this motion seeks requires only that the Commission's relief from order not be arbitrary, capricious, or an abuse of discretion, and that the parties have notice of the proceeding. Quote, we know of no rule or law that denies to a court the right to revoke an order and substitute in lieu thereof a new and different one, provided the court has not lost jurisdiction over the case. An administrative agency unquestionably has the authority, just as a court has, to reconsider and change its orders. That's Secretary Labor Cabinet versus Boston Gear 25 SW 3rd. Quote, an agency not otherwise constrained may reconsider an action previously taken and come to a different conclusion upon a showing that the original action was the product of fraud, surprise, mistake, or inadvertence, or that some new and different factual situation exists that justifies the different conclusion. That's Calvert County Planning Commission versus Howling Realty, 772A2. Courts have uniformly concluded that administrative agencies possess inherent authority to reconsider their decisions, subject to certain limitations, regardless of whether they possess explicit statutory authority to do so. As Miller and Wright explained, Rule 60 regulates the procedures by which a party may obtain relief from a final judgment. It was derived from a number of sources, including Equity Rule 72, the statutes of various states, and federal decisions. The rule is designed to remove the uncertainties and historic limitations of ancient remedies while preserving all of the various kinds of relief that they afforded. The advisory committee noted in the 1948 amendments to the rule that the rule does not assume the definite substantive grounds for vacating judgments, but merely prescribes the practice and proceeding to obtain relief. The rule balances two opposing views: that litigation come to an end, and the value that justice be done. Rule 60 allows relief in two ways. One is by a motion to the court where the original action was brought, and the other is for a new and independent action. Rule 60 is not intended to is not to be a relitigation of issues that had been resolved by a judgment and is not a substitute for appeal. Instead, its purpose is to address circumstances where some change in conditions make continued enforcement inequitable. This includes subsequent legislation, change in the decisional law, or a change in the operative facts. None of these instances are addressable to reconsideration or rehearing because these changes in conditions occurred after the period to seek rehearing or reconsideration. The failure to obtain an incidental take license within the time contemplated by the agreement voids the Commission's approval. Neither HECO nor MPM are empowered to modify, waive, or amend the Commission's approval. Life of the Land is not raising a breach of contract claim as it is not a party to the agreement. Rather, Life of the Land is raising the fact that MPM failed to obtain site control as required by the approved PPA and therefore failed to satisfy a condition of the approval, which should render the approval void absent some affirmative action by the Commission. Site control is a requirement of the competitive bidding framework, and to the extent that this project obtained waivers from part or all of that framework, all deviations from it must be strictly construed against such waiver. HRS 2696B requires the Commission, in making determinations of reasonableness of costs of utility system capital improvements and operations, to explicitly consider quantitatively or qualitatively greenhouse gas emissions. The Supreme Court concluded a primary purpose of the amended law was to require the Commission to consider hidden and long-term costs of reliance on fossil fuel, which subjects the state and its residents to increased air pollution and potentially harmful climate change due to the release of harmful greenhouse gases. That's in Re Miko, 141 Hawaii. Order 32600, to the contrary, made no explicit consideration, quantitatively or qualitatively, about greenhouse gas emissions or fossil fuel reliance, but rather made a general conclusion that the first PPA was consistent with the state's energy policy of reducing dependence on fossil fuels. The subsequent Order 34866 made no findings either about greenhouse gases or fossil fuels. Equitable relief is appropriate because Life of the Land was prejudiced by the conduct of the proceedings which did not comply with the statute or the constitutional obligations of this Commission, and a change in decisional law regarding this Commission's obligations now compel it to provide that meaningful opportunity to be heard. Wind energy is widely generated at prices of 2 cents per kilowatt hour, while the PPA approved a levelized price of 14.998 cents per kilowatt hour. In light of the fact that although approved years ago, this project has still not come online and did not comply with the approved deadlines, MPM should not be entitled to a levelized price that is far beyond the range of prudent and reasonable and is not in the public interest. In conclusion, this Commission has jurisdiction to entertain this motion. The motion is not one for reconsideration, but relief from the order. NPM failed to obtain site control as approved and required by this Commission, and neither it nor HECO has sought to be excused from those requirements or otherwise sought to modify its obligations. HECO and NPM have no authority to vary or modify this Commission's approval. The proceeding failed to consider greenhouse gas emissions as required by law, and the development of decisional law by the Supreme Court and such failure deprived Life of the Land from asserting its rights, foreclosing the opportunity for a fair proceeding. Finally, the levelized price of this project, in light of the failure to comply with approved timelines, makes it far outside the range of prudent and reasonable or in the public interest. We therefore ask the Commission to vacate the order and dismiss the docket, to vacate the order and reopen the proceedings, or to open a new docket to investigate these matters further. It should be noted that over 200 members of the community have been arrested for engaging in acts of civil disobedience regarding this project. Hundreds of community members have submitted public comment in support of this motion. In my limited knowledge of dockets and projects before this Commission, such a situation is unprecedented. This is exactly how we don't want the community to respond to renewable energy projects. We have a serious and urgent need to end our reliance on fossil fuels. It is undeniable that our actions now and that of the first world over the last 100 years has modified the atmosphere in ways that will continue to have a huge and costly impact on all humans throughout the world for a long time to come. The time for action is now. However, in taking action, we must also not sacrifice our values as a community, including the value, may I finish my sentence?
Please, yeah.
including the values of kindness and tenderness, unity, harmony, patience, and perseverance. The trajectory of this development has shown that NPM has demonstrated none of these values, but rather has shown the Kahuku community and the rest of our state meanness, disunity and disharmony, and impatience and shortness. There is a connection between the failure to follow the law and comply with the Commission's approval and the steamroll approach to community concerns we see expressed in mass arrests and repeated end runs around various land use laws. Thank you.
Thank you, Mr. Collins. Commission Council, any questions?
No questions.
Commissioner? Commissioner? I have no further questions either. With that, we'll move on. Next to present arguments will be Mr. Wada from Hawaiian Electric Companies.
Thank you, Chair. Good afternoon, Commissioners. Before I begin the substance of my argument, I just want to point out that I think that I heard half a dozen cases in that statement that were not contained in any of the briefs that were submitted in those materials. So we strongly object to the extent that new cases are being cited at this oral argument that we won't have an opportunity to respond to. Ultimately, Life of the Land has raised a number of issues. One of those issues, though, is utterly fundamental to the matter before the Commission. So I think it makes sense to start out with jurisdiction. One of the basic concepts of our Constitution at both the state and the federal level is that there are three branches of government: the judiciary, executive, legislature. Administrative agencies like the Commission are unique. They are not created by the Constitution, they're created by the legislature, the executive branch. This does not make administrative agencies any less important. Indeed, the specialized knowledge and expertise that they bring to complex areas are key to the modern society that we live in. But because of their unique status as creatures of statute, agencies are, for better or worse, constrained by the statutes that created them. This means that where the legislature sets a time limit on the time for appeal, as it has indisputably done here, that time limit is strictly enforced. The Hawaii Supreme Court explained in the Governor Cleghorn case, an administrative agency may not enlarge its powers by waiving a time requirement which is jurisdictional or a prerequisite to the action taken. This rule has been confirmed by a number of cases, but the most extreme example is probably the Tanaka case that we cited in our briefs. In Tanaka, a state agency terminated a resident's lease after the resident was convicted of a crime. Because he was in jail, that resident was unable to file an agency appeal of the lease termination. He was able to file an appeal of his criminal conviction, and that criminal conviction was eventually overturned. After the criminal conviction was cleared, he went back to the agency and he said, look, the basis under which you terminated my lease no longer exists. The reason that I wasn't able to appeal this under the timeline was because I was wrongly incarcerated. Even under that scenario, the courts ruled that the agency's decision simply could not be reconsidered because it lacked jurisdiction following the expiration of the statutory period. In an effort to try to avoid these clear requirements, Life of the Land has tried to import Rule 60B of the Hawaii Rules of Civil Procedure into this proceeding. In its briefs, Life of the Land argued that this was proper because of a commission rule stating that whenever this chapter is silent on a matter, the commission or hearings officer may refer to the Hawaii Rules of Civil Procedure for guidance. This argument fails for numerous reasons. First, as the rule itself states, it's for guidance only. There's nothing mandatory about that rule. Second, this is not a situation where the commission's rules are silent on the matter. There is a rule governing motions for reconsideration and has a 10-day time limit on it. Third, even under Rule 60B, most motions must be brought in a reasonable time period, not 5 years after the order at issue. But the most fundamental reason that Rule 60B is not applicable here is that agency rules simply can't be interpreted in such a way as to alter a jurisdictional deadline that was set in a statute. To be clear, we believe the commission's analysis should end here. Because there is simply no jurisdiction over the motion, there's nothing further for the commission to consider. However, I believe that the commission can rest assured that there is no basis for the substantive matters raised by Life of the Land. With respect to the greenhouse gas issue, Life of the Land has made two arguments. It claims it would be inequitable not to consider greenhouse gas, and it claims that the failure to conduct such analysis somehow rendered the commission's decision void. Commissioners, neither of these arguments has any basis in the law or in the facts. First, the case law makes clear that equitable rules that Life of the Land is seeking to invoke are only to be used in extreme situations where the moving party can show that they have been the victim of oppression. Moreover, Life of the Land's attempt to invoke equity on this issue ignores one of the fundamental rules of equity. He who seeks equity must do equity. This means that a party is not permitted to take a position that is inconsistent with its prior positions. As the Hawaii Supreme Court has put it, they can't blow hot and cold on the same issue. That's exactly what Life of the Land is doing here. Life of the Land has opposed other power projects because they were not as protective of the environment as the wind farm projects like this one. In those cases, Life of the Land has claimed that wind power has negligible greenhouse gas emissions. Life of the Land has stated that among the choices available in Hawaii, wind farms have far lesser negative climate change impacts. Life of the Land has called wind and solar truly clean, carbon-free sources of energy. Given the positions that Life of the Land has taken in the past, its attempt to invoke equity here is disingenuous. What is more, even if Life of the Land could show that there had been some legal violation here, that is not sufficient to void a decision and order from the Public Utilities Commission. It's a central tenet of our adjudicative process that in order for a commission or a court to issue a ruling, there must be some form of harm. Both the United States Supreme Court and the Hawaii Supreme Court have made clear that it is not sufficient for a party to identify an abstract violation of law. The party must also identify a distinct and palpable injury caused by that violation. We don't have a gotcha legal system where you can point to a legal issue 5 years after the fact and upend a years-long process. There has to be some harm in order for a court or a commission to look at that issue. Your Honor, or Commissioners, one issue that I didn't hear from the Life of the Land today is the idea that was in their briefs that the PPA should be thrown out because of the alleged delay in an incidental take license. They have been here at least emphasizing the purported site control issue. But in either issue, I think the argument is the same. First off, site control has occurred. A lease has been obtained by Napua Makani. They absolutely have the right and they absolutely have site control. The fact there has been no breach of the PPA in that regard. But even if there had been a breach of the PPA, that doesn't magically void the PPA in its entirety. The PPA itself addresses what happens if there's a breach of contract. Under Article 13 of the PPA, it explicitly addresses delays in the project and describes the damages that Napua Makani would be required to pay if there were delays. Article 15 addresses other events of default and discusses the penalties and procedures for handling other breaches of the agreement. So the parties and the commission envision this agreement operating over a long period of time, and the agreement describes how to handle the situation if there is a breach. If there's a breach, you turn to the agreement. You don't tear it up. I think that Life of the Land's comments about the energy costs deserve relatively little comment. The PPA approval process very closely and in depth considered the energy costs under this project. A detailed analysis was performed, and this is just an attempt to re-argue something that's already been carefully considered by the Commission. Before I conclude, there are two final points I would like to make. There have been numerous public comments filed with the commission related to this motion. Many of those comments have focused on environmental concerns, such as noise and shadow flicker, or planning issues, such as proximity to other developments. The commission is just one part of a larger regulatory system here in Hawaii. The commission's mandate is reviewing and improving rates, tariffs, charges and fees, evaluating acquisitions, mergers, and other utility properties. There are a host of Hawaii agencies that have responsibility for different regulatory areas, including those raised in the comments. Those agencies have already been deeply involved in this process. The final point I want to make is on the issue of the delay of Life of the Land in filing this motion. Life of the Land is a sophisticated litigant that has made a conscious decision not to file an appeal earlier in this case. According to its executive director, Life of the Land is, quote, the most prolific commission intervener in major community energy disputes. In its briefs, Life of the Land touted 5 decades of experience. My point is just that, with your...
Please summarize.
Yes, thank you. Life of the Land knows better than anyone what are the rules and the appellate requirements in this sort of situation, and they made a conscious decision not to appeal in this case. As the Supreme Court has stated, there must be an end to litigation someday, and free, calculated, deliberate choices are not to be relieved from. Thank you, Commissioners.
Thank you, Mr. Wadoff. Any questions, Commission Council? Commissioners?
No questions.
No questions for myself, thank you. Okay, moving on, Consumer Advocate, you have up to 10 minutes.
Thank you, Chair Griffin, members of the commission. Again, Lane Tsuchiyama, appearing on behalf of the Division of Consumer Advocacy. The Consumer Advocate would like to thank the commission for providing it with the opportunity to participate in this motion hearing. It would also like to acknowledge the presence of the community, some of which are here today and have traveled a very long way to be at this motion hearing. We would also like to recognize the many, many other people who may be viewing or following this hearing online in order to keep informed on a project that will affect the communities that they live in. But let me be very, very clear here. This motion today is about the assertions and contentions raised in Life of the Land's motion that the Commission's decision and order, that would be DNO number 32600, filed, I believe, on December 31, 2014, is void. While the Consumer Advocate is mindful of, and in fact is sympathetic to the fact that the community's perspectives have been expressed since Life of the Land filed its motion several weeks ago, the Consumer Advocate's position on this motion hearing today in particular, and on this motion specifically, is that the motion filed by Life of the Land is about one thing and one thing only: whether the commission should entertain Life of the Land's motion, arguments, and requests in this docket through this particular motion, when A, Life of the Land filed no challenge to the DNO within the timeframes allowed by the commission's rules and the statutes relating to appeals when a party disagrees with a ruling made by a commission in any given docket, and B, the procedural posture and process through which Life of the Land presents its arguments in this proceeding. Through this very motion, again, that we're discussing here today, presents a very strong and distinct possibility that a decision even considering Life of the Land's request for relief here can potentially set a precedent and a course for seeking relief in the future where no commission DNO can be considered final, determined, and the docket closed, because a party, notwithstanding their level, character, or nature of their participation in the docket previously, can present arguments or assertions declaring the DNO to be void years after the ruling is made in the docket. This level of uncertainty, the inability to know or predict with confidence when, where, or even if a decision in order will be challenged by a party in the future on a decision that has not been appealed or challenged within the rules set by the commission in keeping with its statutory authority, can result in a state of affairs where the commission, the Consumer Advocate, and the community that we both serve can, for instance, face higher costs in the services that they receive from a utility because the motion seeking relief on a DNO long after the DNO has been decided by the commission presents a situation or circumstance where interested investors or decision makers, for example, may ask for higher returns for the money that they devote to a utility project, if they invest that money at all, to account for the fact that the project may be challenged long after the decision and order has been issued in a docket. The commission should not ignore the potential impact that the requested relief that is asked by Life of the Land in this motion to retroactively void a past DNO that it could have on all of the utilities, because this is not just a matter relating to Hawaiian Electric and the NPM PPA in this particular proceeding. But the consumer advocate would like to remind the commission that any decision that you do make here will apply to all other regulated utilities that are under the jurisdiction of the commission. So what the commission decides to do here is monumental in the fact that if it grants Life of the Land's motion here, there is the potential that any and all utilities regulated by the commission can follow the same pathway to revisit orders or rulings or DNOs of the commission long after the ruling is issued by the commission. So you have the filings that we have made in the docket, and including our statement of position that raise questions with regard to this particular PPA. So I will not repeat that here in the interest of time. However, I do want to point out to the commission that what is interesting here is that Life of the Land's motion filed in the docket presents what at least the consumer advocate interprets to be Life of the Land's primary contention for deciding that the commission's DNO is void in this particular instance. And that's that events that occurred after the commission issued its DNO in this docket, which was December 31, 2014, that all of those events after the DNO rendered the DNO void retroactively because the commission did not consider information that did not exist at the time when the commission made its decision in the later part of 2014. So it is worth noting that the relief sought by Life of the Land here with respect to the DNO is a remedy that is extraordinary in the sense that it should be entertained and considered only under very unique and specific circumstances. As is detailed in the consumer advocate's filing in the reply that was filed earlier this week. Essentially, the commission either has to A, lack jurisdiction to render the decision and order in the first place, or B, the parties have had to have acted in a manner that is utterly inconsistent with due process of law in this instance. A fair reading of Life of the Land's motion suggests that Life of the Land does not contest the commission's jurisdiction to issue the DNO here. So it appears to be that Life of the Land's contention is that circumstances that occurred after the DNO was approved in the docket work to affect the NPM Hawaiian Electric PPA relationship in some way, but that fact in and of itself doesn't render the DNO void. Recognizing Life of the Land's argument made in its motion in this way, through this motion for relief made by Life of the Land in this instance, is what the consumer advocate is arguing against and advocating for denial here, because it sets a set of conditions where no DNO can be considered final, determined, and non-appealable, because there's always the possibility that the DNO can be challenged in the manner advocated by Life of the Land here. The consumer advocate observes that there is a good system in place right now through the mechanisms and procedures set forth in HAR Chapter 16-601, for example. And it should be noted that the Commission's document management system indicates that Life of the Land did not file any objections to or make any filings after the Commission ruled upon the application through the DNOs issued in the docket. As mentioned by Hawaiian Electric, Life of the Land is a prolific intervener and at times party in many dockets open before the Commission. So it is noteworthy that Life of the Land declined to make a filing after the Commission issued its DNOs in the docket. The existing process allows for reconsideration, and for rehearing where necessary. And it doesn't appear, at least from the DMS, that there was any filings after the DNOs were issued in the docket. While not determinative of the issues presented by Life of the Land in its motion, the consumer advocate does observe that Life of the Land's failure to provide any challenge to the Commission's DNO in this instance should count for something as far as any suggested motion or reconsideration or rehearing is concerned. The consumer advocate asserts that such concerns should be considered waived and should not be considered by the Commission to the extent that any request for rehearing or reconsideration is entertained in this docket. The consumer advocate would just like to point out and highlight that Life of the Land's motion, again, we're only focusing specifically on Life of the Land's motion for relief in this situation. It should not be entertained because while it may be deployed for what may be a noble and justifiable reason in this particular circumstance, it can just as easily be utilized for something that is not as noble or may be detrimental to the customer in another instance in the future. Rather than worry about that potential at all, the Commission should just deny Life of the Land's motion, and if the Commission agrees, it could address the concerns raised in Life of the Land's motion in another fashion through another regulatory mechanism available to the Commission under the Commission's statutory authority. So, in conclusion, we would like to thank the Commission for the opportunity to provide the consumer advocate's perspective on the motion filed by Life of the Land in this instance. And if the Commission has any questions, we stand ready to answer them at any time.
Thank you. Commission Council, no questions?
No questions.
No questions for Ray either. Mr. Collins?
Thank you. I will first respond to some of the points made by the consumer advocate, and if time permits, then address whatever he had to say. I think what's very important for this commission to understand about this motion, and I think Life of the Land agrees that how the commission decides this motion will set a precedent. And it's very important that the commission identify the standards by which it evaluates motions for relief. And while this is not perhaps a usual procedure for the commission, courts face this question all of the time. This area of law is well developed. It's not a mystery. It's not earth-shattering. And we agree that it would set a precedent. And it should set a precedent, and the commission should very clearly announce what the standards are by which this commission evaluates motions for relief. We don't agree with the consumer advocate that granting this motion, clarifying what the standards are for motions for relief, will necessarily increase transactional costs. I'm not sure that any other renewable energy contractor is looking at this proceeding thinking that they are like NPM. This particular contractor has cut corners and broken a whole series of laws that either individuals don't have standing to challenge, or the time to challenge that has passed, or they simply don't have the money. I think most renewable energy contractors don't have that problem, and so I don't think that they would be worried that they would be facing a motion for relief, because this contractor is very much not like any other contractor. And the standard by which this commission evaluates this should not be on the worst possible case scenario of a so-called speculative challenge, but actually the facts that are before you in this case itself. It's possible that in this case that there might be something that eventually would be passed on to ratepayers, but that's already happening. We're looking at about 15 cents per kilowatt hour of levelized price. I mean, I think that NPM could probably do all sorts of really bad things and get away with most of it, and consumers wouldn't be affected. They'll still just be paying a really high price. The issue with a Rule 60 motion is that the facts that give rise to the change in circumstances don't exist at the time that the decision is rendered or 10 days thereafter. And that's what the classic motion for reconsideration or rehearing is. It's the traditional form by which a litigant can seek for the tribunal to reconsider its decision. That's under Rule 59, and like the HAR here, the litigant has 10 days to seek relief under that rule. And then after that, you can't do it. So the only way to seek relief from a decision after that time, if circumstances change, is by bringing a Rule 60 type motion. And while it is true that Life of the Land is a prolific participant, I don't think that this commission could adopt as a standard, as is suggested by the consumer advocate, that even a prolific filer or participant would need to have clairvoyance and be able to forecast within 10 days of a decision what changes in circumstances might occur years later. That's why there is a Rule 60 motion. It is to make sure that justice can be done. And while the finality of a decision is one of the values that are to be considered in a Rule 60 evaluation, so is getting the right decision and doing justice. Those two are supposed to be balanced. I'd like to take up HECO's claim that, citing the very well-known equitable maximum, he who seeks equity must do equity, and then by quoting statements that Life of the Land has made in other dockets with respect to wind energy. And while all of the statements are generally true of what Life of the Land has said about wind energy, Life of the Land has never made a statement about this project ever in another docket. And so, I understand that, HECO's position is they want to protect the purchase power agreement, but there's no equitable estoppel, there's no issue here of having contradictory positions. Generally, wind energy is cheaper, and it does generally engage in less consumption of fossil fuels. The problem is that the general fact that that is true doesn't waive the Commission's statutory and constitutional obligation to explicitly consider greenhouse gas emissions and the hidden and long-term costs of fossil fuel consumption, because not every project is the same. So in the way that HECO wants to generalize what Life of the Land has said to say that Life of the Land is making contradictory statements, that is not in fact the case. And that is why the Commission in every docket is supposed to consider the long-term and hidden effects of fossil fuel reliance and greenhouse gas emissions, because each project is different. And in this case, that was not done. So he who seeks equity has done equity in this case. We agree that we don't have a gotcha legal system, and we also believe very strongly that the approval of the PPA did not delegate to the private parties to that PPA to determine when a violation has occurred with respect to the Commission's approval. And that is what separates a breach of contract claim from a violation of the approval claim. Because to argue otherwise, why would there be a purpose of having a Commission approval in the first place if once the approval is done, HECO can do whatever it wants? It can just agree with its contractors that they're going to make changes to the agreement. What is the purpose of having the Commission approve the terms of the PPA if then HECO is conferred with unlimited discretion to change that whenever they can get the contractor to agree? And that is an absurd contention. HECO argues that that administrative agencies are constrained by their statutes. And as we've noted, this commission has ample authority to grant all or some of the relief that has been requested. In this case, there's no constraint in the statute. There's nothing in the statute that gives any restraint to this commission modifying or reopening its decisions. HECO cites to appellate statutory deadlines for appeals to say that this commission doesn't have the authority, but those cases and those statutes and rules limit the jurisdiction of an appellate court. It does not limit the jurisdiction of this commission. It has nothing to do with this commission. So it is agreed that if you do not file an appeal within 30 days, and there are a few exceptions, doesn't matter what case, doesn't matter what court it is a general rule that if you do not file an appeal within 30 days, the appellate court does not have jurisdiction to hear your appeal. It's a pretty bright line rule. There's a few exceptions related to foreclosure and certain interlocutory decisions of courts, but that is a general rule. And yet that says nothing about what this commission's jurisdiction is, because this commission is not an appellate court. So all of the argument that HECO is raising about time limits on appeals have absolutely nothing to do with this commission's jurisdiction, because this commission, I'm sure as you folks all know, is not an appellate court. So the 30-day rule has nothing to do with this commission, but HECO has spent a significant amount of time on it, and we obviously don't agree. It's also important to note that the consumer advocate and HECO have not clearly identified what the differences are between a motion for reconsideration and a Rule 60 type motion. And that is important. It's important that this commission clarify what that is. There are no rules in the commission's rules with respect to how a participant or a party seeks relief from an order. And in this case, we argue that there are clear grounds for that relief, but there are all sorts of instances where parties may need to seek some kind of relief from an approval years after approval happens, because there was something that was unforeseen that happened, that the strict application of the approval would actually be detrimental to ratepayers. And so it's not just in this instance where a Rule 60 motion is appropriate, but there are generally other instances where, to the benefit of ratepayers, a Rule 60 motion would be appropriate. And that's why determining what the standards are so important. Mahalo for the opportunity to provide argument today.
Thank you. That concludes the oral arguments on the motion for relief. Commission will be taking this matter under advisement and will not be issuing an order on Life and Land's motion today. After carefully reviewing Life and Land's motion, the associated briefing, and the transcript from today's hearing, the commission will issue an order at a later date. As I mentioned earlier, you can sign up online to receive email notifications from this docket. You can also file public comments with the commission. They're entered into the record through our document management system. Thank you all again today for your participation and attendance. We stand adjourned. Very good. Thank you.